Service contracts are a part of our daily lives, from cell phone plans to gym memberships. But what happens when you need to cancel one? Understanding the ins and outs of service contract cancellation is crucial to protect your interests and avoid potential legal pitfalls. A valid service contract requires two key elements: mutual assent and consideration. Mutual assent means both parties have agreed to the terms, while consideration involves an exchange of something valuable. Once these elements are in place, canceling a contract isn't as simple as just walking away. There are several legitimate reasons for terminating a service contract. The first is impossibility of performance. This occurs when unforeseen circumstances make it impossible for one party to fulfill their obligations. Imagine ordering products from a supplier, only to find out their warehouse burned down the day before shipment. In this case, the supplier can't fulfill the order, making the contract impossible to perform. Fraud is another valid reason for cancellation. This happens when one party intentionally deceives the other for personal gain. For example, if you order printer ink cartridges and receive empty ones, with the supplier clearly aware of the deception, you have grounds for termination due to fraud. Mutual mistake can also lead to contract cancellation. This occurs when both parties are mistaken about a crucial fact related to the contract. If this mistake significantly impacts the performance of the contract and neither party could have anticipated it, termination may be justified. Breach of contract is perhaps the most common reason for termination. This happens when one party fails to perform according to the contract terms. However, for the contract to be terminated, the breach must be material, meaning it significantly affects the core of the agreement. If you find yourself needing to cancel a service contract, there are several steps you should take. First, obtain and review the original contract. Verify that it's the exact agreement you signed, with correct dates and signatures. Collect all related documents, including past bills and receipts. Carefully read through the entire contract, paying special attention to the cancellation clause. Note any penalties or specific terms related to cancellation. Make a list of your reasons for wanting to terminate the contract, along with the potential advantages and disadvantages of doing so. It's often worthwhile to contact the other party to see if they're willing to release you from the contract with reduced liability. If you're terminating due to the other party's failure to perform, document all instances of non-performance or breach. When initiating the cancellation process, always provide formal written notice as specified in the contract. Keep copies of all correspondence. If there are penalties for early termination, consider negotiating with the other party to reduce or waive these fees. Remember, not all breaches are equal under contract law. A material breach is a significant failure that provides grounds for immediate termination. A minor breach may only entitle you to compensation, without the right to terminate. An anticipatory breach occurs when one party indicates they won't fulfill their obligations, often allowing the other party to terminate before the agreed date. In complex cases or when dealing with high-value contracts, it's advisable to consult with a legal professional. They can provide tailored guidance based on your specific situation and help ensure you're taking the right steps to protect your interests. Understanding service contract cancellation is essential in today's world. By knowing your rights and responsibilities, you can navigate these situations confidently and effectively, ensuring the best possible outcome when a contract no longer serves its purpose.